Dave, I don't know, this is, you say early on, and it is one of the first discussions in any law school.
Right.
I'd never heard of it. Perhaps you have. Thin skull rule versus crumbling skull rule.
Right. So it's a concept in tort law, and basically the thin skull rule comes from a case way back when there were two boys who were in the playground. One boy struck the other boy over the head with a stick, the kind of strike that would not normally have caused a very serious injury, but in this case, the boy who was struck suffered a very serious disability. And so the case went through the courts. And what was learned in the court system was that, or through the medical system, was that the boy who was struck had an unusually thin skull, and therefore his brain wasn't protected. And so the boy who was being sued as the assailant said, hey, listen, I can't have known that. I can't be responsible for the consequences of my actions when my actions were so minor. And so the court did the whole analysis, and essentially the court said, look, there are people out there with frailties, with pre-existing conditions, vulnerabilities, and you take your victim as you find them. And so you are responsible for the consequences of your actions. And so the boy was responsible for all of the disabling effects of hitting, even though not very hard with a stick. The competing concept is the crumbling skull doctrine. So, for example, the defendant will often say, okay, well, this person's hurt. Let's go back and look at their medical records. Oh, okay, well, this person has, let's say in a car accident case where there's a complaint of a back injury. Well, they had scoliosis, were going to physio, they were going to a chiropractor. This person's skull was deteriorating anyway. It was a crumbling skull, and so this accident wasn't really what caused the disability. This person was going to be disabled anyway. So you've got the thin skull where you take your victim as you find them and you're responsible, and the crumbling skull where it's argued that the person was going to be disabled anyway, so we shouldn't be responsible. And many of the cases that we deal with have these competing doctrines.
You say you deal with this every day?
Pretty much every day.
Practice.
Yeah, because if you're hurt in a car accident or something like that, one of the first things that the insurance company wants to see is your past medical history. So if in the last 3 years you've been to a chiropractor a couple times, they're going to say, your back injury isn't from this car accident, it's from whatever, standing too much at work.
So you need to have a lawyer who can help you explain that.